looking at the freedom of speech and expression. The first two were with regard to the preamble and Article 12 and 14, which is the right to equality and the defining state. But what I would request, I mean, you have already heard the first two lectures, please bear the principles that have been explained and enunciated in the earlier lectures, because they would be relevant throughout the entire series of lectures, because as we said, the preamble is a beginning and it sets out the tune and the tenor for the rest of the interpretation of the Constitution and to understand its fundamentals. Now we have in the fundamental freedoms, which is all citizens shall have the right to freedom of speech and list of other rights which have been given to us. You see on the screen, please it should be peacefully and without arms. Or society move free throughout the practice any profession or to carry on any occupation, trade or business. While we have listed out, today's lecture is confined or restricted to the freedom of speech and expression alone, because this one, it is very important. It is considered as a lot of an entire session to explaining what do we mean by the freedom of speech and expression.
One second, we are tracking.
Without the PPT, it may be difficult for them to follow because it's a lot of text. Should we wait or shall we proceed? Yes, fine. So now, as you can all see, we are dealing with clause A, which is the freedom of speech and expression. And once you are in the screen, what you would notice is that only in respect of clause A, you will find the word freedom. So all citizens, 19(1) starts with all citizens shall have the right. And A alone says to freedom of speech and expression. The rest, which is B, C, D, and F, do not have the word freedom. It is just says you'll have the right to assemble peaceably and without arms, to form associations or unions or cooperative societies, to move freely throughout the territory of India, and to practice any profession, trade, etc. The reason why I wanted to emphasize on that is that the freedom, the word freedom there signifies the importance that has been given by the framers of the Constitution to the right to speech and expression. So it is not merely a right. They have said that it is actually emphasizing that you have the freedom, which is the freedom of thought, the freedom of knowing what you have to speak. So it encompasses an entire area of free speech. In the next slide, we deal with restrictions on free speech. As we have explained earlier, when we were dealing with the preamble and with Article 14, no right is absolute. No citizen can enjoy absolute rights, because all rights are in relation to some other competing rights. It could be competing rights of one individual or competing rights of other individuals. So it could be competing with individuals, it could be competing rights within a given context. So in both ways, no right is absolute, and it is subjected to certain restrictions which have to be reasonable. Now, but as far as free speech is concerned, the Constitution itself spells out what are the restrictions which the state can impose. So now I will just read the text slowly, because it would be important that you note the relevant provisions. Nothing in subclause A. Now, subclause A is the earlier paragraph that we saw, which is the citizens will have the right to exercise freedom of speech and expression, which is clause A is only with the freedom of speech and expression, shall affect the operation of any existing law, because this was at the time of constitution, so any of the pre-constitutional laws, or prevent the state from making any law insofar as such law imposes reasonable restrictions. Now you would note that we have underlined the word state, law, and reasonable restrictions. So here it would mean that the restrictions, one, will have to be made by statute. In the earlier session, we had explained the broad sweep of the word law. But since this is coming within the restriction clauses, we will have to give it a very strict interpretation. Now, this is another rule of a thumb rule which you all have to bear in mind, that generally when rights are given, it is interpreted in an expansive way. And when certain restrictions are placed to these rights, or when certain exceptions are given to these rights, which takes away or which restricts the main clause, then the rule of interpretation is that these exceptions or restrictions should be given very narrow and strict interpretations. So viewed from that context, when we say prevent the state from making any law, courts have said that this means it should be a statute, which is a law made through a legislation, or it could be subordinate legislation like rules or notifications given under a statute. So I hope that distinction is borne in mind, because earlier we were dealing with the expansive understanding of law. So that expansive understanding may not be relevant here. So insofar as such law imposes reasonable restrictions, now these are terms again which are of very big significance when we are looking at the law itself, because reasonable restrictions here, the word reasonable has a lot of meaning in it, so please bear that in mind. Reasonable restrictions on the exercise of the right conferred by the said clause in the interests of, now these are the list of restrictions which the article contemplates. So the government can restrict your exercise of the freedom of speech and expression in the interests of sovereignty and integrity of India, in the interests of the security of the state, friendly relations with foreign states, public order, decency or morality, or in relation to contempt of court, defamation or incitement to an offense. I mean, this is quite a mouthful. We have now broken down each one of them in the subsequent slides. So the summary of the restrictions on free speech is in the next slide, where we have just listed out in a vertical manner, so that if the next slide could come on, it would help the viewers. The state can impose reasonable restrictions on grounds of defamation, decency. It's the same list, but we have just listed out as in a tabular column. So this would help you to get a clearer understanding of it. So I won't read it all over again. Now, this is broadly just to give you a summary of the content of clause 19(1)(a) and the restrictions which is in clause 19(2). Now, let us look at, before going into further analysis of the words in each of these clauses, I think it's important to understand what is the value of free speech in a democracy. Why free speech at all? Why is it that free speech is given such importance in every constitution? In US, it's called the First Amendment rights. And in fact, that was one of the conditions for many of the states to sign in to the Declaration of Independence in the United States of America. So the First Amendment rights are guarded very zealously by everybody. And even in our country, the right to freedom of speech and expression is of considerable importance. And at every point in time, attempts are made to expand it and to give the most narrowest of interpretations to the restrictions. The values of free speech have set out in the subsequent slide. Now, broadly, if you look at the entire jurisprudence of free speech globally, these principles can be culled out from the various judgments and discourse in respect of free speech. First, one essential thing, all of us know that free speech gives us individual self-fulfillment and self-expression. It is very reassuring that all of us can speak our mind, that there are no restrictions. Nobody can tell us, speak this but not this. So it is a very important aspect of an individual's self-fulfillment and self-expression. So this is a very, very primary value of free speech, and that is why it is very zealously guarded by everybody. The second is advancing knowledge and discovery of truth. So without free speech, we may probably lose out on a lot of knowledge and in discovering truth. All of us are familiar with the whole incident of Galileo, where when he's articulated that the earth is not the center of the universe, but rather the sun, he was silenced, and it has put us all back by several centuries because the church silenced him from articulating this truth and thereby advancing our knowledge of the universe. So the price of restricting free speech actually is very, very heavy, and it could in fact impact generations to come. So that is why they said that one of the values of free speech is to advance knowledge and to discover truth. The third, creating a critically informed and discerning community of citizens. Now, this is again very, very important from the context of the preamble, where we have said that the preamble we have given to ourselves, we have the Constitution and equality, liberty, fraternity. These are all the values which we all intend to realize in the Constitution. Now, if we want to realize these goals which we have put up in the preamble, it is important that we as citizens keep ourselves informed, and it's not just any information, critical information. That is, to be able to critically look at any information. I mean, today we are living in the world of fake news, and hence it's all the more that we have our critical faculties in comes to it. We should be able to critically analyze it and discern. And so by allowing this kind of a critically informed citizen, what we are also creating is a community of such citizens. And a community of such citizens is very essential for a democracy. So the next point 4, providing for participation in decision making and democratic processes by all members of society. So point 3 leads us to point 4. Only when there is a community of critically informed and discerning citizens that we as citizens can participate in decision making and in the democratic processes of all members of a society. So this is the only way that we can participate effectively in any democracy. And if we want to ensure that as citizens we facilitate the rights of all other citizens, we need to have respect and tolerance for diverse, antagonistic set of thoughts, beliefs, and ways of life. I mean, if it was homogeneous, if everybody thought alike, everybody acted alike, if everybody had the same set of beliefs and thoughts, I mean, there would be no problem, but that is not the reality. I mean, in fact, it would be very boring. But apart from boredom, reality is not that. It is a very diverse country, diverse cultures, diverse religions, diverse faiths, beliefs, diverse thoughts, and very often these are competing thoughts. It could be antagonistic, but nevertheless, it is important that we respect and have tolerance for such diverse views, for the simple reason that only when such diverse views are tolerated, the earlier values that we have spoken about, which is the individual's right to self-fulfillment and self-expression, to advance knowledge and discovery of truth, and to have a discerning citizens and discerning community where we can effectively participate. Now, all these values can be realized only if all of us bear in mind, again, the concepts of liberty, equality, and fraternity, which is what is point 5 about, which is being tolerant of diverse and even antagonistic views. Now, having looked at the values of speech, a very, very important component of free speech is dissent, which we have looked at in the next slide. Dissent is always key to democracy. And The reason why we thought that dissent should be a standalone slide in this entire discussion, because most often it is with dissent that there are problems. It is dissent which creates tensions, which creates some heartburns. But it is very, very important that we understand that dissent is a key to democracy. Dissent is an essential part of democracy. And when we say dissent, it just doesn't mean political dissent, but it also means cultural dissent. And dissent, speech that criticizes existing customs, habits, traditions, institutions, laws, and authorities. It is only when there is a citizenry which questions the existing customs, questions the existing traditions and institutions and the authorities that there can be advancement in our country, where we will further the values that we have explained in the earlier slide. So, and the Supreme Court of India has recognized that dissent is a very, very valuable key to democracy. And just to quote a judgment of the Supreme Court in S. Rangarajan versus P. Jagjeevan Ram, open criticism of government policies is not a ground for restricting expression. We must practice tolerance to the views of others. Intolerance is as much dangerous to democracy as to the person himself. Now, to give you the background of this quote, Rangarajan versus P. Jagjeevan Ram was in the context of, I don't know if how many of you, I mean, people in Tamil Nadu would probably remember the movie Ore Oru Gramathule. That was a movie which, in fact, criticized the reservation policy. So it is in the context of an upper caste person who obtained a false caste certificate and got into government service, but turned out to be an outstanding officer. And so the movie is on the whole debate as to how reservation takes away the opportunities for meritorious candidates. Now, this obviously had a lot of social repercussions, and especially in Tamil Nadu, where people opposed the release of this film, and people said that it would create a lot of unrest. And then the Madras High Court took the stand that this film should not be released, though it has received the certificate from the censor board. It should not be released. And then the producer, Mr. Rangarajan, took it up to Supreme Court. And then the Supreme Court said, well, yes, this could be a theme which may not be acceptable to most, but then we are in the era of free speech. And if free speech is not permitted, then it could become a very dangerous precedent. And in fact, they go on to explain that it is a duty of the state to give adequate protection to citizens so that they are able to enjoy these fundamental rights. And the role of the state here is to protect and facilitate the enjoyment of these rights, and not to curb it in the name of social unrest or the fact that there is a section of society which is aggrieved by the exercise of these rights. So that is why dissent is a very, very important aspect of free speech, and it is something which all of us should value. Now, to go back into the nitty-gritties of free speech, while speech, as we understand in the ordinary sense of the term, we would be looking at speech as talking. But you would notice that in the slide, which we have explained, that speech includes written works like poems, songs, slogans, and pamphlets. You name it, everything comes within free speech. Okay, let me just okay, so can you do that style? I think I skipped one slide, but we can go back to it later. And it also deals with advertisements, commercial material. All this is a component of free speech. Movies, television, theater, dance, art, hoardings, pamphlets, symbolic speech like showing a black flag or wearing a black armband, the right not to speak. So speech also includes the negative, which is the right not to speak, such as refusal to sing the national anthem. I think this is something which all of us can identify with. We had a situation in the country where if you go into a theater, which was essentially for entertainment, all of us were very tense about being politically right in standing up when the national anthem was played in the theaters. And at that point in time, What was publicized was the subsequent judgment of an observation of the Supreme Court, where they said that yes, every theater should play the national anthem and every citizen should sing the national anthem. But what is important for the listeners today to realize is that in as early as in the year 1970s, in the 1970s, we had a case coming up from the Kerala High Court, where the question was where children who owed 85, it is I think it's 85, a sect which was from the Jehovah's Witness, which is one of the sects of Christianity. They said that their religion does not allow them to bow their, to sing any other anthem apart from what their religion prescribes. And since the education department of the Kerala government state issued a circular saying that it is compulsory that every child sings the national anthem, and the children who refused to sing the national anthem were thrown out of the school. And it was in this context that the matter went up to the Supreme Court, and then the Supreme Court said, well, the right to free speech also includes the right not to speak, and hence the children refusing to sing the national anthem cannot be found fault with. And it was in this case that they also explained that the education department in Kerala did not have the right to issue such a circular because there was no statute authorizing them or giving them the power to issue such a circular. So as I said in the very first explanation, that there has to be a statute which prescribes a restriction to the freedom of speech and expression. Now, the refusal to sing the national anthem by itself is not showing disrespect, because you also have the other enactment which is dealing with our national symbol and showing respect to the anthem. But that is only when you prevent a person from or obstruct a person from giving respect, showing respect, or you show disrespect. But the mere refusal to sing the national anthem is not a violation of. Now, there is one other point which I think the slide, I do not know if it is visible. Now, the online social media posts on Facebook, Twitter, your Instagram, all this is also part of your exercise of freedom of speech and expression. And today, clicking a like, clicking a thumbs up or a thumbs down, all these are all your speech, and which would be included in your exercise of freedom of speech and expression. Now, free speech by itself would become meaningless if we as a society are ignorant and we are completely uninformed and we have no method of understanding before we articulate. Can we go to the next slide, please? So, the courts have repeatedly held that the right to free speech includes the right to know and the freedom of information. So, your Right to Information Act has actually come as a fallout of the courts holding that right to freedom of speech includes the right to know. So, right of citizens to know the actions and decisions of the government is derived from the concept of free speech. I mean, unless we as citizens are informed, now how do we even participate in the democratic process of in your governance and in your other systems? Casting a vote is also an expression of free speech. So just as we in the earlier slide said, how singing a song or articulating or putting up or protesting, all that. So even casting your vote is an expression of the free speech. And in the PUCL's case, in a judgment of the Supreme Court, most of you are now aware that candidates, when they contest elections, they have to file an affidavit setting out their antecedents. Now, this has come as part of the judge-made law, where the People's Union for Civil Liberties went to the court and said that there are a lot of criminals who are contesting elections, and hence it is important that citizens are informed about the antecedents of the candidates who are contesting in elections, and only then the citizen can make an informed choice when they are casting their ballot. So this has been a extension of the freedom of speech and expression, because if casting your ballot is an expression of free speech, then the right to know the antecedents of your candidates before you vote is also part of this very freedom that the constitution has granted us. And it was in this context that the candidates have now been asked to file affidavits disclosing their assets, disclosing their antecedents, whether there are any criminal cases pending, etc. So all this is springing from this valuable right, which is part of the fundamental rights given in our constitution. Now, on the scope of Article 19.1, Suresh will take it over from here.
As Saila has already explained, the right to free speech is not just a moral right or a social right, it's actually a very valuable political right. Now, the foundations for the right to free speech, of course, goes back to the Magna Carta and subsequent times. It also goes back to a tussle between the executive and the legislature, and between the executive and the people. It's in this three-corner type of a fight over many, many years that the right to free speech got crystallized in various countries. At the time of the constitution framing, there was a huge debate inside the Constituent Assembly as to whether and in what manner should the right to free speech be incorporated in India. This was particularly potent because we were fighting the British, who had a multiple set of legal principles as it related to citizens. One was that they were the ruler and we were the ruled. They would give information as they thought fit, and people had no right to ask for any further information. Two, the limits of democracy was prescribed by the colonial master and not by the people. And three, citizens did not have any right to ask any questions or criticize the government. If they did do that, then they had the pain of law hitting out at them and then getting arrested. So when the Constituent Assembly, the issues came up, the debate then got formulated in two or three very interesting parts. One is to say, should you have absolute rights or should you have restricted rights, as the way we have it now? The debate went on in a very heated manner between various sets of people, between one set of people saying you cannot replace a white master with a brown master by giving them all the powers, because ultimately it will be the state which will determine what exactly is an infringement of free speech right, and therefore will violate and put people down. Vis-a-vis others who said no, in a culturally diverse country like ours, with the type of complexities of cultural, social, economic, and political structures, an absolute right will ultimately work out to the disadvantage of the very marginalized sections, and therefore you need to have restrictions on the exercise of the rights. It is in this tussle that the entire key section, which is Article 19, got formulated. Like Saila had pointed out in the second slide itself, there were originally 7 freedoms. They were called the 7 sisters, or the 7 freedoms of the Indian Constitution. Actually, entire Constitution revolves around Article 19. There was one particular fundamental right, which was the right to property, which was removed during Indira Gandhi's regime, which then got substituted as Article 300A as a constitutional right. Barring that, we now have 6 rights within the fundamental rights regime. Of all the 6 rights, you have the right, Article 19(1) A, B, C, D, and F. For each of those rights, you have restrictions, which is Article 19(2), 19(3), 19(4), 19(5), and 19(6). These are the restrictions. So when you look at the restrictions, it's also very interesting to note that the maximum number of restrictions is in the provisions of limitations to right to free speech. And the question therefore becomes why and how. And it's some of these restrictions were built in later, which are not there originally, but those restrictions came in. If we were to go to the 4th slide right from the beginning, where after we talked about, can we go to the 4th slide from the beginning, where we list out the restrictions. The ones before this, please. Before that. No. Yes. Just stop here. What we have tried to do is to summarize the restrictions and put it in a natural flow. The slide before this, actually, we have extracted the actual provision. If you look at the 8 restrictions that have been placed, you will see a certain ordering, which is not very apparent when you actually read the original section. Now, there are 2-3 things. As Saila has already explained, it has to be, it is a state which will impose reasonable restrictions. So the restrictions will have to stand the test of being reasonable. When you look at it, what are the grounds? Defamation, decency or morality, and public order. This is one set of grounds on which free speech can be restricted. Second thing is, the second part of it is security of state, friendly relations with foreign state, and maintenance of sovereignty and integrity. These are 3 things related to the state. I mean, whatever is the understanding of the state, but the larger state. And then you have a third variety. One is if the speech is in terms of contempt of court. And the last one, if the speech or expression is an incitement to an offense. You can actually take 1, 2, 3, and 7 together, because they all constitute activities which could be that of both individuals or that of groups. Now, a very simple thing that will strike you when you look at the issue of defamation, decency or morality, public order, and incitement to an offense is the fact that it all depends upon the thinking of the person, which here in this context, the state, in whose view a particular expression may constitute a defamation or decency or be indecent or immoral. Now, what is indecent or immoral are extremely subjective matters. This is very much related to a whole variety of factors, including the caste, the community, the type of education that they are from, in urban, rural, and a whole lot of other diversity factors which come in terms of defining whether a particular expression is indecent or immoral or is defamatory or is an incitement to an offense. Now, what in effect happens is that these 4 particular clauses has given so much of a power to the state in a context in which the state already has a tremendous amount of power, that ultimately much of the freedom of speech and expression is then curtailed by the definition of these 4 subjective matters. Now, here we need to understand one thing. It is not just the state which decides as to whether these issues have been violated. It is also sets of people who may come forward to say that they have been defamed or something has been scurrilous or indecent or that it is an incitement to an offense. Now, we need to keep this in mind. So, in effect, these 4 conditions which impose restrictions on free speech ultimately are subjective matters which fall within the definition of the state in terms of the politics of that state group. In this, I'm just taking a step out of this frame to say that there is a definition of offense in the criminal law, which says the law defines the offense, but the state defines the offender. Now, this is not what is said, but this is how it actually operates. The law defines the offense. Now, in criminal law, the law says this is the offense, but whether action has to be taken on that particular offense or not, ultimately is dependent upon whether the police will do it. Whether the police will do it will be dependent upon whether the government, which controls the police, decides to take action or not. A classic example is what happened with the agitation in the CAA. There were people who were belonging to the ruling BJP party, very clearly inciting people to attack the protesters in the CAA side. Till date, no action has been taken against them. Other people who talk the language of democracy, who talked in the language of dissent, most of them or many of them have been prosecuted, and a large number of young people have been recently prosecuted, especially under Sedition and Unlawful Activities Act. Very draconian provisions which will ensure they will never get bail and come out easily. I'm mentioning this particular aspect because when you get back to the issue of decency and immorality, and you get back to incitement, it is who is defining whether it is an incitement or it is immoral or it is indecent. Ultimately, it is a subjective evaluation of the person in power, which happens to be a state person. Now, I'm bringing this to the attention of everybody because this gives a tremendous amount of power to the state agencies. And also now I would like to introduce one more aspect here, which is that apart from the state, issue that has taken place in recent times is the actions of what are called non-state players. This is not just the state which is imposing censorship or imposing conditions on free speech. It is people who are non-state players, who are other social groups and other people who use their might in terms of the might of numbers to silence people who may be expressing what they think is right. Now, we have seen repeatedly many of these things happening. We saw that in the context of the attack on several films in recent times, several books in recent times. For example, the attack on M.F. Hussain, then Khushbu. In the last 10 years, there are innumerable number of instances where non-state players entered into the scene and came up by thwarting free speech. The action of the non-state players, when it is supported by the state, ultimately then becomes a potent combination to muzzle free speech. Again, these are the second aspect I would like to ask people to keep in mind. The third part is that friendly relations with foreign governments, incitement, etc., are again very dangerous powers, because any action of questioning the government, as Saila has already pointed out, dissent is an innate right that we have. And like we already talked about in preamble and in the earlier chapter on the right to equality, Supreme Court itself has said the fundamental rights are not given to us. What the Constitution does is only to recognize rights that we already have by virtue of being born as human beings. Now, this is an extremely important moral point which we need to keep. It is a democratic value. So it is in this context that if you challenge the government in terms of any policy, the government may turn around and say, no, this, you're threatening us with incitement, with making people go against us. And that itself can become a basis of an action against the government to pull you into under sedition. Now, before we get into the interpretation of courts on other issues, the last point, when we already say that right to free speech is very much an aspect of democracy, we need to understand one key underpinning of constitutional democracy. The key principle which underlies the notion of democracy, as it has developed over the last 300 to 400 years in various places, is the fact of regime change through elections. The change through elections is actually brought about through the ballot. In legal terms, this is called replacing the bullet with the ballot, where in earlier times, one regime was thrown out through battle using sword and arms, resulting in bloodshed. This was replaced in modern eras through constitutional democracies, through ballots by which people exercise their right to vote against the existing government, to throw them out and to bring in a new government. Here comes a very important legal conundrum. How do I as a person, or I as part of a group, get people to understand that the present ruling government and its policies are anti-people, and therefore to go against them, unless I create disaffection against the existing government, unless I create discontentment, or unless I create anger amongst them in terms of the existing government. So an innate part of constitutional democracy is where you have opposition groups, that opposition groups will naturally tend to criticize and oppose the party, the policies, programs, and laws of the ruling governments. Now, it's very easy then at this point in time for the ruling government to turn back and say, your actions constitute a threat to democracy, and therefore they are seditious, and therefore you need to be put under sedition law. All these issues are based on real life experiences in India in the last 50 years, with the exercise of powers under sedition, under UAPA and other very draconian provisions, linked with the whole issue of the fundamental right to speech and expression. With this backdrop, we will go into some key principles that have been evolved by Supreme Court through a variety of judgments. And we will go to, first, the issue of what is the scope of Article 19(1)(a). Now, we need to understand what is the scope, because one key thing that, as you would have already seen in the three classes of issues on which free right can be limited, was on the fact that, if somebody feels that their notions of morality or their notions of sensitivity has been breached, and therefore it constitutes something on which you can demand that the freedom of speech should be curtailed. One case came up with the film in the 70s, with the case of K. Abbas versus Union of India. There, the Supreme Court said that if somebody is going to say that my sensibilities or sensitivities are affected, then how do you judge whether that sensitivity which is being affected is correct or not? Does that sense of anger reflect the anger of a wider section of people or not? Those issues went up to the court, and the court came up with one principle which is extremely important that we need to keep in mind. And they said that when you are looking at the whole issue, that a particular person or a set of people feel that a particular speech or expression is against their interest or against their cultural norms, what you will have to look at is what would be the sensitivity of an average person and not the most depraved amongst them. Now, this is an extremely important one. I mean, important issue, because there would be hotheads in every single community grouping that you may find. Now, would that necessarily, therefore, lead to your to an inference that a particular expression needs to be curtailed? So, when there is a demand for a book to be banned, a film to be removed, or a picture to be taken out of circulation, the question is, who is to judge that? Now, there are two folds here. One is the person who will be complaining would be from within the community, and second, it will also then be tested in terms of the official who may have taken an action or not. Here we need to keep in mind that in the context of films, you have the Central Board of Film Certification, which at least looks into a thing. There's a procedure that has been prescribed for films to be released or not. Whereas in terms of books, you don't really have censors in that sense of a group of or an agency which will decide whether to allow publication of a book or not. Of course, in the context of artistic issues, that thing doesn't exist at all. Therefore, the point then becomes important. The index should not be the most depraved amongst them, but it has to be a different pole. Then in that question, came the next issue. I think the key thing has been lost out in the bottom of the thing, which says the effect of the words should be judged in the standards of a reasonable, strong-minded, firm and courageous man, and not those of vacillating minds who smells danger at every point of view. Now, we again in our day-to-day interactions will come against people who will pick up criticisms or who will complain at just about every smaller thing to go about. They cannot be the index of judging that somebody's sensibilities have been affected or not.
Just coming in here for a minute. And so essentially what courts have done over the years is to create this fiction of what you consider as a reasonable person. So ultimately you judge any aspect from the standpoint of a person who is considered to be a reasonable person. And of course, who constitutes or what constitutes a reasonable person is again subjective. But this fictitious, reasonable human being is been a standard by which most judgments have evolved over the centuries. And so when you're looking at reasonable people, you mean that people who are sensible, who are not hypersensitive, who are also able to discern the facts, and who are able to understand what is good and bad, and then come to a reasonable conclusion. And so the test is always, will such a person who has these reasonable sensibilities, who is able to make out the right from the wrong, who has his emotions within control, would such a reasonable person react to certain speeches? So that is a standard which mostly courts have evolved over the period.
This came up in particular in a recent case, and it's a very celebrated case of a book called Madharu Bagan, written by a Tamil author called Perumal Murugan. This became an issue throughout the country. He wrote this book, Madharu Bagan, which is a fictionalized account of a certain communal practice that happened in his native place. The caste group to which he belonged to and which was represented in the book came up in arms and said, no, this does not represent us and this is bad. It's licentious. It is also allowing for sexual orgies to take place. Now, this sexual orgy business became a huge issue. They mobilized in tens of thousands of people to demand not just a ban of the book, but also an arrest of the person. And this matter went up to the Madras High Court, and there the issue came again. What is obscenity? What would constitute obscenity, which would sort of provoke the type of reaction that it is there? Is it the standard, as what Silas said, the fictionalized entity of an average person, or is it political calculus that is at play in terms of how it has been done? Now, you will realize that in the last 5 to 6 years, there have been lots of these issues on which many of these things have gone about. Recently, for example, on the whole issue of the role of the various RSS leaders in the freedom movement, an attempt is being made to rewrite history books. A writ petition was filed in the Tamil Nadu, in the Madras High Court recently, on the fact that this is not history, but it's a very different history than what is actuality as according to that particular group. Now, here comes the whole issue of what Saila had talked about earlier on the whole issue of finding the truth. Now, if ultimately the whole issue boils down to the sensibilities of a majority group saying that we will allow only this and not that, truth is the greatest casualty. And this is what we need to keep in mind when we are looking at the issue of the scope of the freedom of speech and expression. The second point, the second set of factors, which is in the next slide, which says that when looking at a particular issue, we have to look at the work in its entirety. You can't pick a word here and there. You cannot take a passage here and there. You cannot take a slide, or you cannot take a particular scene in a film and then say this is particularly bad. You cannot do that. You have to take it up in its entirety. Now, it's very interesting that in the case of Gopal Godse, way back in 1971, who is the brother of Nathuram Godse, the issue came about in terms of the book that they had written and the book that was celebrated from within the RSS in terms of their basic Bible, vis-a-vis the freedom movement, the role of Gandhi, and what to do with Gandhi and others. There, at that time, the book was banned by the government of Bombay, or that time it was called Bombay and then subsequently Maharashtra, which said that the work in terms would help incite enmity between Hindus and Muslims, leading to law and order problems there. So this matter, when it went up to the Bombay High Court then said, look, you cannot look at it from this point or that point or this passage or that passage. You cannot tear it out of context, because the moment you tear out a particular thing, then that becomes extremely problematic. And then it can, merely those words alone can tend to inflame anger and to get people riled up. But you have to look at it in the larger context in which a particular issue has been talked about. In the later slide, we will also talk about, for example, in the film Utta Punjab, which talks about drug dealers in the Punjab border. I mean, it's a recent film where the filmmaker, the director, has got people to talk about an extremely, what in urban terms would be called a very coarse language of people who reside in that area. So the matter went up to the court. Finally, the Bombay High Court said, look, you cannot look at it from the sensibilities of a upper class person sitting in the city. When in the picture, the director wants the character of a youth in a border area of Punjab who has become a drug addict, who's looking at the drug addiction in context of the politics of that, he will obviously talk in very coarse, uncouth language, which is the language of people of that particular milieu in that particular area. You can't sanitize their language and ask them to speak a language that somebody in the city would want to have, which would be breaching the rights, the creative rights of the filmmaker. And there they stuck at the fact that the Central Board of Film Censor, who had asked for major deletions of the various dialogues, scenes of youth in the rural areas, talking very, what would otherwise be very shockingly uncouth matters, should not be deleted. So going back to the slide, you will also notice that you will have to, in Anand Patwardhan's film, Anand Patwardhan is a person who is a very famous documentary filmmaker who has brought about a lot of films looking in a very social, political context on contemporary issues. Many of his films which talk about life at the bottom of the pyramid, which talks about politics as experienced by the most marginalized sections, and also with a very critical, unforgiving, very strong analysis of the role of upper class elite in India. Many of the films were banned, were not allowed to be to be released or shown in Doordarshan. In one of the films that was banned, which went up to the Supreme Court finally said that it was only one portion. You cannot take the portion of the film in isolation, but again, you have to look at it as a whole. Now, this is an extremely important point that we need to bear in mind. In the next slide, we will look at the next point on the whole issue, which is what would be the test of obscenity. Now, you have looked at the standard. The standard cannot be the standard of the last man who's very excitable, but it has to be standard of an average man. Again, a mythical creature called the average person or a reasonable person. The second part, we looked at the fact that you cannot pluck out particular stances or scenes. You have to look at it in its entirety. Third would be the whole issue of obscenity. In the case of Maqbul M.F. Hussain, a criminal complaint was filed against him in terms of the famous paintings of his pointing out to Bharat Mata in various contexts. So one Hindu person went to the court and filed a criminal complaint saying that is extremely obscene. It is going against showing Hindu religion in poor light, and it is something that should be banned. The criminal complaint was taken on file. Summons was issued to him to appear. Now, at that time, M.F. Hussain, fearing for the fact that many such cases had been filed in numerous courts across India, that he would be arrested. He was already very old at that time. He left India and sought exile in the Gulf. It's a matter of great tragedy that he did not come back to India and he had to die in exile outside of India. Now, in this particular case, the court went again into great detail. The Delhi High Court, Justice Kaul, who's now in the Supreme Court, was there at that time, and he gave this judgment. He said, to find out the whole issue of obscenity, the judge should place himself in the shoe of the author so that they can appreciate what the author really wanted to convey. And thereafter, he must place himself in the position of the reader of the group in whose hands a book may fall, and then arrive at a dispassionate conclusion. Now, this is again a test. Now, one may say that the same problem that exists with the viewer may also exist with the judge. It is true. You have judges of all types who are coming in. Much of this is also cultural sensibilities. But ultimately, in the legal system that we have in India, the final arbiter of whether something is obscene or not goes back to the court and to the judge or an individual judge or a bench to look at it. There, this particular ratio is important. It says you cannot look at it again. You cannot take it out in isolation. You cannot pick and choose, but also look at what is the context in which a particular piece of art or poetry or a film has been brought about. What was the purpose that that person wanted to do, and how does it fit into that particular purpose? And you cannot again go back into the other things of merely wounded sensibilities. That cannot be the test. In another case involving again a film actress, Khushbu, who had given an interview in the television about premarital sex. Can you come back to the slide again? Where and against which many people in Tamil Nadu filed cases against, criminal cases against her.
She had actually given an interview to India Today magazine where she said that society should stop expecting women to be virgins at the time of marriage. So this was part of the interview which was published, and 23 criminal complaints were filed against her, saying that she was affronting the dignity of women, and that her it's actually corrupting the morals of women in Tamil Nadu. Yeah.
So it is in this context that these cases came. Many groups filed casing that this is very obscene. It's challenging the chastity of Tamil women. It's against Tamil culture and various other fairly emotive type of grounds which were raised, and it went up to the court. So when it went up to finally reached the Supreme Court says, pointed out to several things which also sort of resonates with the whole issue of dissent. One of the things is to talk about there are obviously going to be expressions which will go against the grain of what is popular knowledge or popularly accepted as acceptable information. Now, how do you then judge whether a particular issue is obscene or not? And what would be the test to look at it? So this case of Khushbu is extremely important for several things that they talked about, which is to say that one of the aspects of free speech is also that you need to be able to tolerate unpopular views, not just in the personal sphere, but also in the social cultural sphere. They also go back to the Constitution to talk about the fact that this was one of the safeguards which was thought about even at the time of the framing of the Constitution, which is very important to sustain the collective life of the citizenry. And only when there's an informed citizenry, which becomes a precondition to meaningful governance, can you really have not just the right to free speech, but also the right to democracy. It is in this context that they said a culture of responsible reading has to be inculcated amongst the prudent readers. Now, when you talk about responsible reading, now it raises a new dimension to the whole issue of freedom of speech and expression. Till now, we've been talking about freedom of speech and expression from the viewpoint of the person who's creating the free speech. It could be a filmmaker, it could be a journalist, it could be a book writer, it could be a poet, it could be a painter, it could be a sculptor, it could be anybody. So when you're talking about responsible reading, you're now talking about the other side, which is the person who is consuming whatever is that has been produced. Now, does the right of free speech have a corollary of the right of the person to whom much of this speech is aimed at? Do they have a right also in the context of free speech in terms of the curtailment of a right? Now, this again is something that has been developed in the last 20 years, which is an extremely important right. And we shall just see that very shortly. Now, what they talk about here is also in minds of what we will see later on in terms of the fundamental duties. An expression of opinion in favor of a non-dogmatic and non-conventional morality has to be tolerated. Now, this is extremely important. Non-dogmatic, non-conventional morality. There could be morality of various types. Even in the last lecture, I shared with you all about the issue. There are probably about 1,200 Ramayanas in India. But the current dispensation in India today wants only one variety of Ramayana and one type of Ramayana that can be portrayed. So the communities in which Rama is the villain and Ravana is the thing will have to now rewrite their history. Is that fair? Isn't it that going against their freedom of speech and expression? Do they have a right to talk about it? And do we, all of us who are listening to this talk, do we have a right to hear the views of Bhil communities talking about Rama as a hero and Rama as a villain? So many of these issues which are contested are actually very important issues of democracy, which cannot be straitjacketed into formula, which will have to be expanded. These are issues which are now coming up in the social media in terms of the modern electronic devices. But we'll go back to the test of obscenity as it has been evolved over a period of time. The issue then came, if it is obscene, then it is vulgar. Then how do you understand vulgarity? I will not put on too much time here because we already talked about the Utta film, Utta Punjab film. Can we have the full text of the slide, please? Now, you can read for it because I've extracted it from the Madhurabhagan judgment of the Madras High Court, in which they talk about, they quote from the Bombay High Court on the Utta Punjab film. Then it ends up by talking about the fact the court has a view that the blanket direction of the CBFC correcting various cuts because of the use of abusive words is unacceptable and it infringes the artistic freedom. This is a thing coming up again and again. For example, when Asim Trivedi came about with this cartoon showing Parliament like a toilet seat, and then that again went up to the Supreme Court because the Maharashtra government at that time filed a sedition case against him for the cartoon that he had printed. There are numerous other things. The same thing has happened in Punjab, in West Bengal, vis-a-vis cartoons and jokes about Mamata Banerjee. Ultimately, in fact, the Supreme Court has variously said that people in public places will have to expect that there are going to be people who are going to take pot shots at them, and they have to develop a thick hide. In the slide after this, we will see that having looked at obscenity, we now look at the issue which comes up from earlier, like I said, the right to be informed is also the right to be educated. So now you come up to a new thing, the right of the listener, the right of the reader, the right of the person who's being entertained. So when free speech is being curtailed, it is not just the speech of the person who's creating the content. It is also us who are seeing it. This again went to the Supreme Court, and it is a case that in which the Supreme Court also said that it also includes the right to educate, to inform, and to entertain. So it's a dual thing. There's a tension between both. And you have to keep both these tensions in mind if we have to look at the entirety of the free speech thing now. This is of particular significance today because you have now a ruling dispensation in India, which itself does not say prohibit speech, but allows a whole lot of non-party, non-state players to demand bans, to fight against them, to create all types of problems. And that disturbance is then taken up by the state to say this creation of a law and order problem or a public order problem, requiring the entire work to be banned. Now, this is extremely important. For example, now again, may not be directly related to free speech, but just to talk about how current politics is seen. Now, this is a point I would like viewers to keep in mind. The big significant difference between the emergency and what is happening now. When you look at what has been happening now in the last few years, the emergency looks like some kindergarten class of a of an earlier period. Such is the type of a thing. What Indira Gandhi did overtly, the present ruling dispensation is doing covertly. Arogya Setu is one classic example. The Prime Minister says it is voluntary, it need not be compulsorily taken up by everybody, and there's no further information from them. The government of Uttar Pradesh has said that all citizens in the state, if they come out of their house and move around, have to have an Arogya Setu in their hand. There are people who are saying we don't want to take up Arogya Setu, but if you are a citizen in Uttar Pradesh, you cannot come out. The central government then says that all central government employees will have to necessarily take Arogya Setu. All state government employees have been told that they should take Arogya Setu. All people who are taking welfare schemes have to take Arogya Setu. Now the state of UP says you have to take it. The railway ministry yesterday came out with a circular to say no passenger will be allowed in a train unless they take out Arogya Setu. Then what is the great fun in the head of the national government saying no, it is not compulsory, it is left voluntary for people to do. Same trick was done in Aadhaar. And similarly, it keeps on happening time and again. So we need to keep these things in mind that you have to contextualize many of these things. And unless you contextualize many of these issues, we may not be able to understand the whole thing. This is where the free speech aspect of right to education needs to keep in mind. In fact, this is one of the issues that we had taken up in some of the cases involving free speech, which we had fought out in the High Court in a wide variety of issues. I shall now rush through because it's taking quite a bit of time.
Now, the other, we have, Suresh has covered some of the restrictions. The other category of restrictions which is important is the rights being restricted on grounds of public order or incitement to an offense or security of the state. Now, I mean, this slide doesn't contain that, but anyway, just to explain to you, now the terms public order, security of state, and incitement to an offense have been dealt with extensively in many judgments of the Supreme Court. And so Supreme Court has said that now every law and order problem cannot become a public order. See, law and order, they have described it as three concentric circles. So the smallest circle is, your security of state. So which means it's a very, very narrow compass. The slightly larger, the mid-level circle would be the public order, and the wider circle would be the law and order. So law and order would be, even a small neighborhood altercation can create a law and order problem in that area. But it doesn't mean that every situation of law and order can result in a restriction on your fundamental rights. Because what Article 19(2) contemplates is a public order, only in the interest of public order that the state can impose restrictions and not for law and order. And that is why they say that in Rangarajan versus Jagjeevan Ram, where the court has said that if there is a crowd which is creating a law and order problem, because that's what Tamil Nadu government said, that if the film is being screened, then we have demonstrations, there are people who are threatening that they will break down the theater, etc. So the court said, well, that is, if they are creating a law and order problem, then it is for the state to protect and ensure that this law and order is curtailed, is maintained, so that the citizens who are interested are able to exercise and enjoy their fundamental freedoms. So the court has made this distinction between law and order, public order, and security of state. So the words public order and security of state have to really have a very narrow and restricted understanding, and every situation of law and order cannot be a justifiable reason to restrict your freedom of speech and expression. And the other aspect is on the incitement to an offense. Now, does it mean that anybody who says, oh, today the government is a bad government, we should bring it down, or any criticism to say that, oh, let's lay siege to the parliament? For instance, recently, as part of the CAA protest, some of the groups have said that we will lay siege to the assembly. Now, this is a symbolic statement. It is not literally capturing the assembly. These are all symbolic rhetoric, which very often people make. So now, does every such rhetoric or any such statement, does it amount to incitement of to an offense? And here the courts, over a period, now this kind of an understanding did not happen overnight. So they said it cannot be some remote, distant future. There is likely to be somebody who may, as a result of this speech, may commit an offense. Because we are not looking at that. When you are looking at an incitement to an offense, what the courts really were looking at is imminent danger, immediate and imminent danger, that the moment, like for instance, in an already surcharged atmosphere, supposing there are a group of people who have already assembled with arms and, tempers are flying high and there's already a situation of unrest. And in such a situation, then if somebody makes a speech which is inciting people to go ahead and carry out the offense. For example, what happened in the demolition of the Babri Masjid? Already, there were all people were waiting with crowbars, and then you had speeches made, and people went ahead and demolished it, which the court has said that it was an illegal act, the demolition. The subsequent that they have given a direction is a different matter, but they did say that it was an illegal act. So incitement to an offense, it should be something which is immediate and which has an imminent threat of the offense being committed. So in fact, the language that they use in Rangarajan's case is like a spark in a powder keg. So it should be that there is already a powder keg available and it is just lighting the match. So that is the kind of incitement that you are looking at. It is in that context that you are saying that there is a restriction to your free speech. So it is not every incitement to an offense which is a justifiable restriction, but it should be a spark in a powder keg. So that is the contextual understanding of the restriction. And so any of these words rehearse the context and the situation may make us think that every speech then, oh, okay, this speech looking at these words would amount to an incitement to an offense. So that is not the way to read it, but one has to look at the context in which the speech was made, to the group that the speech was made to, and then again, apply the reasonable person standard and see whether, supposing we are all assembled in a AC hall, comfortably seated, and we are having a academic discussion, and as part of the discussion, people are making statements which would technically be an incitement to an offense. But given this context, given the people who are attending, is it likely that any of them are likely to walk out of that hall and commit an offense? Definitely not. So such a speech cannot be curbed on the ground that it is an incitement to an offense. So the context is very important, and that's what the Supreme Court has repeatedly held in several judgments.
Okay, no, this is important. Exactly. For example, what happened in Delhi, as we've been repeatedly saying, because it's a matter of contemporary issue. One set of people inside another set of people, violence erupts, no action taken against them. Another set of people talk about democracy, talk about opposing the citizenship law, immediately they are booked under. So this is what I was saying. Whatever may be the offense in the law book, ultimately the power is with the state. Now, here I come back to the last part of understanding the whole freedom of speech and expression, which is that, like we talked about earlier, about the state. The last part is, even in a case of law and order problem, the duty is that of the state to protect law and order. So the state cannot say law and order problem is going to come or will be generated, and therefore free speech has to be curtailed. That cannot be a ground. So there are several rulings. We just quoted 2 rulings in the PowerPoint. You can read it later. We are missing time. Where they talk about, for example, in the Delhi case, it is a state's obligation. The state cannot get away from it, saying that there's so much of a big problem that we cannot handle it, and therefore free speech has to be curtailed. Because the courts have repeatedly held that the free speech is of a much higher level than most other rights and not easily to be tinkered with. Now, this is the context in which the tests have been evolved by court. The irony here is that between an incident taking place, between an expression, an incident in which there's a demand that that expression should be curtailed, and it is curtailed or it is blocked and matter goes to court, many years take place or many months take place. Ultimately, in this period, what happens is the sufferer is not just the creative person, but also us as citizens in terms of what is happening. Which is here I go back to the point that we had talked about earlier. An informed citizenry is extremely important. To challenge the government also, where we feel that the government action has been wrong, as what has happened in Delhi. People who incited very clearly and openly gave a call for attacking have been let out. No action has been taken against them. Yet, barring a small set of people, the largest section of citizenry in the country have remained quiet. Now, it's not a matter of isolated to Delhi. It could happen anywhere else, which is where, again, classes like this become extremely important. I'm going to run through the next few clauses, which are the restrictions to free speech. Restrictions must be related to the grounds specified in the limitation in clause 2. This is very important. Beyond the grounds which are specified in Article 19.2, restrictions cannot go beyond. The clauses are exhaustive, which means, like Saila had already said, they should be strictly construed. There has to be a relationship, a proximate relationship between the restriction and the objective for which the restriction is imposed. That has to be shown. These are tests that will ultimately be taken up in the courts. But what we would like all of us to listen, because hopefully there are creative persons who are listening to this, that if there is an attempt to thwart your free speech, please keep in mind of asking them what is it that they want to do and why do they want to curb your speech? Because it's extremely important to know that the reasons given by them most often are unacceptable. The restrictions ultimately have to be reasonable. The test of reasonableness is there in the next slide. One of the important points that we would like to point out here is that the restrictions can be in furtherance of directive principles of state policy. It should not be arbitrary or excessive so as to go beyond the interest of the general public, and it should be reasonable from a substantive as well as a procedural point. The last part of the presentation, after which we'll go to questions, is on the whole issue of defamation. Now, there are both civil defamation and criminal defamation. Criminal defamation is where a criminal complaint is filed under Section 499 of the Criminal Procedure Code as a private complaint in the criminal code. I'm here taking up this issue of civil defamation because this is oftentimes a place where many activist groups, many people working in the social sphere face problems, which is that big corporate interests, big companies, government departments and other people tend up in filing, and politicians in particular, end up in filing civil suits for defamation and getting people locked up in litigation. In fact, the Supreme Court has time and again told in many of these cases that the public servant should develop a thick skin, because there is bound to be people who are going to criticize them. For every single criticism, they cannot go to court. The set of principles the key principles alone, which say that a public official cannot claim defamation for criticism of their public functions, because it is their public function to deliver or to administer, on which people may have differing opinions. Mere fact that somebody criticized their opinion, maybe in a manner in which it was not to the liking of the official, does not give a reason for the public official to go to a civil court and ask for an injunction from the person saying that I'm defamed, they should not be allowed to go ahead with the expression. Then, supposing there is a journalist who writes about the fact that an FIR has been registered against a particular politician for corruption. Now, that by itself does not give rise to a complaint of defamation. Okay. Third is that in civil cases, truth is a defense Along with the truth, if a complaint is made in defamation and it goes to the court, if you take the stand that I am justifying my statement, I am justifying my expression because it is based on truth and I can prove it, then that becomes the basis for refusing to give a gag order as against the creative person. This is repeatedly done. For example, during the elections last year in 2019, in several states, many ruling party politicians went to the court seeking civil defamation, filing civil defamation suits and seeking gag orders against many journalists, saying that this journalist is exposing this or that, exposing that, and it is infringing my freedom of speech and expression. In those cases, wherever journalists have taken up this issue of defense, that whatever I have written is the truth, and that I'm going to justify my statement, in those instances, the law is very clear that interim gag order cannot be given. We'll end up with a final statement, which is being given by Justice Ravindra Bhatt, who's now in the Supreme Court, in a very interesting case of Tata Sons versus Greenpeace. This is regarding the nesting ground of olive ridley turtles in Orissa. Greenpeace had come up with a small social media computer game in which they pointed out to the head of the Tatas, and there was a game in which they played with the Tata logo. So in that, the matter went up to the High Court, where the Tatas asked for a stay. The High Court refused to give the stay. The end of it, the judge recalled the words of Walter Lippmann to say, the theory of the free press is not that the truth will be presented completely or perfectly in any one instance, but that the truth will emerge in free discussions. This is very important, and it links up with what Saila had talked about earlier and what we have been repeating. Ultimately, fundamental freedoms are political rights that we have as human beings. And as part of these political rights, our participation is extremely important, for which we need to be informed. Therefore, we need to have access to creative forms of wide variety of means. And ultimately, it is in the commonplace of discourse, dialogues. It might be very conflicting dialogues, but at the end, it is this process which will bring out the truth, whatever is the truth, or whichever way the truth is seen. And this is part of democracy, which is why right to free speech is an extremely valuable right, which we cannot afford to let loose of, and we cannot but be vigilant at every stage, at every moment. We'll end up the discussion now. We actually overshot the time that we planned for, and we open it up for discussion. Saila wants to give a small summary.
Just to add to what Suresh was mentioning about the litigation against Greenpeace and here against Arapori Yakam organization, which has been fighting against corruption. So most environmental groups or social organizations which have taken up seeking accountability from big corporates or from the government have all been slapped with these kind of defamation cases. And this is a new genre of litigation which has come up, and now the term is SLAP, which is strategic litigation against public participation. So today, the defamation law is being used strategically by the powerful to snuff and to ensure that ordinary citizens do not raise uncomfortable questions. And that is why courts have held that you can't use this kind of a strategic litigation to prevent the public participation of people demanding accountability from organizations in their functions in the public realm, where environment is being affected or where corruption in public transactions is being exposed. So this is again another very important aspect that we as ordinary citizens will have to bear in mind, that how litigation can also be used as a method to silence free speech. So we shall open it up for questions.
Hi, sir. Can you hear me?
Yeah,
Yes.
we can.
Yeah, so that was a lovely lecture. We have quite a few questions. The first one is from Krishna Kumar. What does incitement to an offense mean? What is the standard for incitement?
As I had explained, it means that it should be a spark in a powder keg, which means that
A powder keg is an explosive
ammunition, yeah,
or ammunition which is kept, which can
burst,
at any moment with the smallest
spark.
spark.
So essentially that the speech that a person has delivered will inevitably lead to the commission of an offense. Like, there is no doubt. Like, in this context, if this person spoke this, the logical and the most inevitable, it is not even just logical, what the court says, the inevitable consequence of that speech is leading to the commission of an offense. So that is the test of reasonableness as far as incitement to an offense is concerned. So the context is very, very important.
And also what has been said or what has been expressed, like Saila said, the context and whether it would have that type of a consequence. Most often you will find, in our own experience, none of these things on which cases are filed are ever such a type, warranting the type of action that has been taken to silence free speech.
Okay. So the next question, it's from Adnan Khan. His question is, what is the legal position on hate speech in India with regard to Article 19? As there are so many instances of hate speech by politicians. So if we can understand this in the context of what is the legal position?
See, I mean, one could address it as we have been explaining all along. Now, the dangers of, it is a balance, essentially. I mean, of course, if it is really hurting a person, one could file FIRs invoking the various criminal provisions already available, like, creating enmity between communities, hurting the sentiments. If it is obscene, you could invoke the Indian Penal Code provisions leading to obscenity. So hate speech, definitely, if it constitutes an offense, one could, pursue the criminal prosecution method. The other is looking at it from a broader social political context, where the only real counter to hate speech is to counter it in a way so that tomorrow that hate speech loses its important significance. So I think that can only be the way that we as a democracy will develop, because any curbing of rights could work both ways. It is a double-edged sword. So once one section demands the curbing of one particular speech, which we term as hate, then there could be somebody else who may making a counter demand, and in the end, it is the entire society at large which could, be at a loss, and we might probably be losing our valuable rights. So, in a broader principle, while I'm not, without knowing the specifics, it's very difficult to, give any off-the-cuff answer. But as I said, we need to look at it in a very balanced and in a mature, keeping in mind the larger context and the values of free speech, and that yes, that free speech can be sometimes very painful. They can cause a lot of hurt, but that is the price we pay to preserve our democracy.
I would like to just add on here saying we don't have a shortage of laws to prosecute people for hate speech. There are already several provisions, section 153A, 153B of the Penal Code, section 294B. There are various other provisions which exist in the law by which action can be taken against people who spew hate. And I've heard a lot of these hate speeches, and they are terrible speeches. So, however, I'm also very conscious about the fact that every time that you ask for a new law, it can work any which way, and ultimately and eventually it works out in only limiting our rights in the long term. And therefore, as a human rights activist, part of a human rights movement, I'll be very careful in wanting new laws. We should demand full and fair implementation of existing laws. Those laws are enough. See, what is happening with Arnab Goswami is a taste of his own medicine. The type of hate that he spews in his thing. Now, many people have filed cases against him in several states. Now, before this, if you see in the last 5 to 8 years, right-wing majoritarian groups used to file cases all across the country. For example, they filed cases of sedition against, say, the 40 eminent people who signed a petition and sent it to the Prime Minister just before the 2019 elections. They were made to run from pillar to post, from state to state, in terms of people who filed cases of sedition and various other criminal offenses against them. Now, it is therefore we need to keep in mind that what is being abused is the existing law, and people who are now feeling really that hate speech has crossed a particular limit can use the existing law itself. That itself is a deterrent, in my considered view. It can be work out as a very big deterrent to continuing hate speeches or people who indulge in them. And there is actually not much of a need, especially to bring it. What we could bring in could be amendments within existing laws itself before we think of new laws, because bringing new law can be extremely problematic. Ultimately, therefore, it boils down to one thing, which is the implementation of the existing law. And I go back to that. Implementation of existing law ultimately is determined by the politics of the police, which is determined by the politics of the executive of the state. Now, how does this happen unless we have a awakened citizenry which will question it? Today, it looks very, very grim across the country. But I think somewhere we have to make a beginning by questioning, challenging, going and asking them as to why these things are happening in larger numbers. Because ultimately, we do not want to lose whatever rights that we have, particularly of free speech.
But it's also, I think a positive that today there is a debate on hate speech and fake news. How do you counter it? Equipping people to identify, these fake news. So I think somewhere as a democracy and as a citizenry, there is a debate about it, and there is a feeling that this is something which is wrong and which is not acceptable. So I think that kind of a discourse is going to contribute a lot to ensure that this hate speech is curtailed or people don't encourage it.
So, sir, the next question, can you hear me?
Yeah.
Yes.
Yeah, the next question is by a subscriber called Creative Commons Kindred. So I'm not sure of the name, but the question is very interesting.
Creative what?
Creative Commons Kindred. I think they've subscribed from their channel.
Okay.
But the question is very interesting. It says, while Article 19 is offers protection against silencing actions of the state, what about instances where it is a private individual, like the husband silencing his wife or a teacher silencing the student?
We have the ordinary criminal law in motion. I mean, for instance, if a husband is, violent to the wife, see, that is why we said that law is not the end all for a society to emerge. It is the politics and the social aspects of law, which is equally important to realize the goals of liberty, equality, and fraternity. So individuals, unless you have women standing up and asking for their rights, then we have a social support to facilitate and enable these women to step out of their houses. You also simultaneously create a discourse about gender equality and how men treat their women. And we go back to school education to ensure that there is a debate about gender equality. And if it is, in every context, law doesn't provide a solution to all social evils. And for private disputes, you can always, you have the Indian Penal Code. So if it constitutes any offenses of assault, threatening, assault can be physical and verbal. So that there is the Indian Penal Code provides for it. And if it is defamatory, there is the law of defamation. And if it is, so for very many things, depending upon the facts, there is a law of the land which you can access.
Actually, I'd like to go back to something which many times sounds romantic, but actually is very perceptive on the part of the constitution framers, understanding the type of cultural ethos that we come from. Because if you see time and again, what we talked about in the slide and also what is there in the records, they always talk about a democratic ethos and democratic value system. They talk about social right and social ethos and community rights. This is what is there all across. The constitution makers realize that there are limits to law and there are obviously limits to courts. And we should be very conscious about these things, that law can only do so much and courts can only do so much and you can't go beyond them. But today, the scale of problems in the society is so high that for every small thing, we want a new law, and for every problem that surfaces, we think that the courts are the place where you're going to find solution. No, courts should be the last resort, not the first resort. I think this we need to keep in mind, that part of the constitutional ethos that we, the people of India, when we have given to ourselves the basics of social justice, fraternity, liberty, it is in our hands to create a society which will value this. Therefore, as a society, we will not tolerate a husband beating up a wife, the drunkard who takes away all the money from the house so that they don't have, there's no food in the house. As what we are seeing now in Corona, state after state has now opened up all the booze bars. So obviously, the states are compelled to do it because there is no money. Why have they no money? Because bulk of the money is taken by the central government. It's not brought back into the state kitty. Now, this is a cyclical thing. We sort of talk about it in small circles. The larger populace still does not know about it. At one level, at an individual level, when we confront problems at the family, it looks to be too huge for us to do anything. But somewhere we need to start somewhere. So we need just to keep in mind that law and law courts are only one part of society. Social ethos, social values, constitutional values, constitutional ethos and constitutional vision are extremely important for us as a society to keep going forward. Go ahead.
Yes, sir. So the next question is from Krishna Kumar again. He's asking, are misleading advertisements protected by free speech?
Misleading?
Advertisements.
See, while advertisements and commercials are protected as part of free speech, once it is misleading, for instance, especially you have the Magic Remedies Act. So if supposing somebody tomorrow makes an advertisement saying that I have the medicine to cure Corona, COVID-19, then obviously that person can be prosecuted. One, for spreading false information, and secondly, under the Magic Remedies Act, it is an offense to, it is, claiming making false claims. So there is a law already in place. So yes, false information is not protected.
There are also other standards that have been kept up by various other professional bodies, and complaints can be made and taken to them. And thirdly, if the advertisement is shown to be patently false or defamatory or misleading, you also have the criminal law that you can bring into place and file cases against that particular company which has come out with the misleading ad. So it's not as though there is no recourse or no solution for them. They do exist in the existing law. What is the next one?
Yeah, the next one is again by Creative Commons. They have asked, by which criteria did you club the restrictions on free speech? Can you please repeat that in terms of which bucket is a subset or superset of the other?
We will have to ask you to repeat the question again.
Can you hear me? Yeah, so the question is, by which criteria did you club the restrictions on free speech? Can you please repeat that in terms of which bucket is a subset or superset of the other?
No. There is no subset, superset. We just thought for the sake of convenience. Actually, even that ordering may not be ideal. If you're looking at sovereignty and security, public order, and
morality,
and
decency, morality, and defamation. See, we for the sake of a 1 hour lecture, we needed to therefore sort of make it concise. Otherwise, what would take about 5 or 6 lectures. So there is obviously a personal, shortlisting at our end in terms of putting it. So there's no particular buckets from which we took out each of these things and clubbed them together.
We just thought that presenting it in a particular way would help people understand. So essentially, sovereignty and integrity, security of state, and public order would kind of, everything revolves around state, sovereignty, security. So that would be one sect. And then if you are looking at obscenity, morality, decency, defamation, incitement to an offense, would all be at an interpersonal kind of so it is more for each one's understanding. So there's no particular sanctity to the ordering that we have done.
Okay. So should I ask the next?
Yeah, just to say that there's a wider number of issues that we have left out. Again, basically for practical aspects of time. And this is a field which is very, very, very wide. There are numerous books which also talk about them, and they can be referred to.
Okay. Sandeep Bal has asked, why is there better exercise of free speech in America than in India?
One of the things is that the First Amendment in the USA is supposed to be giving them absolute right of free speech, as contrasted to here, which is not actually very true. Because when preparing for this lecture, as also the other things, there are laws there also, and there are cases there filed against people in terms of the thing. But yes, their standards are much wider than the standards that was adopted in India. Now, when the Constituent Assembly debated this, there was a very major, actually, quarrel of sorts in the Constituent Assembly as to why we should also not have absolute rights or the free speech in absolute right terms. I already said that, talked about this in the beginning part of my my lecture, to say that there were a wide variety of views that was expressed there, but ultimately the constitution makers in India felt that given the country and given the nature of the of society and cultural practices here, you need to have some type of protection, and that is how the whole issue of reasonable restrictions came into place. And then in fact, there was a very interesting, I mean, those of you who are interested should go back to the Constituent Assembly debate to read entirety of the debate on free speech. They're very, very useful today. And many of those things that they talked about today is valid today. What was talked about in 1947 to 49 is still valid today. There's one thing that I would like to share with you at a very personal level, which is that one of the issues which was taken up at that point in time is to say, can you trust the government? Because when Ambedkar put forth what eventually became 19.2, which is the reasonable restrictions, a number of leaders pointed out, a number of leaders who were also themselves victims of the British state and also lawyers, had said that this is placing too much of a trust on the government. Now, this existed, for example, on Article 356 on emergency power, the whole issue of the fundamental freedoms on Article 19. We shall also be looking at subsequently Article 22, 21 and 22 on the whole issue of preventive detention. During the debates, Ambedkar came up. We will, maybe in the next lecture or the one after that, we will read out and share with you the actual discussion that took place in the Constituent Assembly. Ambedkar said, no, in the future India, we hope that these things will not be used. We realize that this is giving too much power to the state, but we think in the future India, there may be no reason or a need to do, because the future leaders may not be like that. Unfortunately, the future India did not turn out to be the way that Ambedkar and the leaders of that period thought of the constitution. What happened 10, 15 years after, not actually 10 years, even the very year that the constitution was passed in 1950, when the case of A.K. Gopalan versus State of Madras came up under preventive detention, and the Supreme Court held that they will not look into the whole issue of the reasons why which preventive detention was ordered against him. It took the court 10 years to change that stand to say that we will explore the reasons, and it took 27 years after 1950 in the Maneka Gandhi case, where the Supreme Court said, we will look into the order directing preventive detention and look into the reasonableness of the order. I'm saying law also marches pushed together by new issues taken up to the court. But we have to understand in 1950, the broader understanding of the leaders at that time. History may show that that understanding may have not been right, but that was the point in which they took a stand, that we should not start a new constitution thinking negatively. Let's think about it positively. It's a lesson that history has shown us.
So again, just to add on to what Suresh was saying, in the US, it is, though the constitution, say unlike in our constitution where the constitution itself provides for restrictions, in the US, most of the restrictions are in terms of the statute law, where the statute prescribes certain offenses. And then when the exercise of free speech also constitutes an offense, like the incitement to an offense, the restriction that we have, which is spelled out as part of the constitution, has the same measure is also there in the US. And the way the courts have progressed, in fact, we have adopted from the case laws from the US, where earlier they said that an incitement to an offense is a valid restriction to free speech. And they said it can be just a tendency to commit an offense, would in fact be sufficient. So if a speech had the tendency to incite a person to commit an offense is sufficient. And so that was a level of restriction in the US. Then subsequently they moved to it should be imminent danger. And from there it moved on to a more narrower definition which is equivalent to what we were saying. So I mean, during the McCarthyism, where communists were being hunted down by the US, in one of the cases, I think Dennis versus United States, where a person belonging to the US Communist Party was convicted, and the accusation against him was there was no particular allegation against him except to say that the general philosophy of the Communist Party of US is to overthrow the government by violence. And the evidence that they marked in that trial was the Communist Manifesto of Karl Marx. So, I mean, so it is not to say that the US has also in some way gone through, though their process had started much earlier, because our constitutional history is very young. So this is the same trajectory that the US courts have also gone through, which we are currently going through.
Go to the next one. I would like to say that if people have further questions to do, please do write to us at kudam.center@gmail.com, so we can start a dialogue on many of these things.
Okay. Let's take, I think we just have another 8 minutes, so whatever is possible, we'll take. Yeah, the next question.
Sir, can you hear me?
Yeah.
Can you hear me, sir? Yeah.
Yeah, go ahead.
So the next question is from Joshua Loco. It is, how do you protect the freedom of speech of the poor when the mediums of publication, be it print, radio, social media, are all outside their reach?
I think that is a very
It's more an issue of access rather than control.
It's a very interesting question, because that is a real issue as far as freedom of speech is concerned, because the economic infrastructure for free speech is with the rich. Unfortunately, that is the situation. To some extent, I think social media has leveled that, because if you were looking at newspapers earlier, you had newspapers are controlled again by the rich. You had the television, which is again controlled by the rich. And so in a way, the Facebook, Twitter, the social media did provide access to the ordinary person. But yes, that also is restrictive in a way, because it is confined to the people who are literate. And there is a large section in our country who may not be literate to begin with, and even if they are literate, to have tech savvy and then to have smartphones. So yes, there is that, but it is more a social issue, which I think as citizens we should be conscious, and must see how we can make this more accessible to the poor.
But I would like to point out, I mean, this is just a little aside on this fact that despite the fact that for many decades, media has been in the hands of the powerful industrial interests, who therefore control both industry, commerce, and also media. It is not as though the ordinary citizen of India is completely powerless or doesn't know what has happened, and therefore we need to keep in mind the fact that they have been mobilized and they have thrown out governments which they felt was very anti-people, and therefore there is a possibility of evolving and finding new ways of reaching out to people through new social media forms. I think even experiments like the Wire, the Scroll, Quint, various other measures are there. It's an unfortunate aspect of our reality, but perhaps we will have to explore now new ways by which to do it. And it's, to my mind, a matter of survival of our democracy.
And the poor did have, I mean, creative means, like, I mean, even traditionally you had gate meetings as far as trade unions are concerned, street corner meetings, writings on walls, graffiti. So it is, and pamphlets. So I think they were evolving their own means of communication. So I hope that answers somewhat. I mean, we don't have a straitjacket answer for it. Yeah, maybe we
Can
can
Vivek
move to the
read the
question.
next one?
Yes. So the next question is from Debashish Nandi. In the current scenario, when accounts are being blocked, videos are being taken down, how does a filmmaker navigate the right to freedom of speech? And what are the steps that can be taken legally by us or by the filmmakers?
So this is a emerging problem because social. I mean, I think when he says accounts are being put down, bringing down, it is I think with regard to the social media accounts,
Correct.
so Facebook or whatever Instagram. Yes, in fact, that is one of the current debates, which is see if you look at the fundamental rights, the entire part 3 itself, as I explained in the very beginning, it is your rights, the citizen vis-a-vis the state. So the citizen vis-a-vis the private player is something which is not there as part of the constitution, but it has to be, for instance, employers. What about restrictions placed by employers or educational institutions? You have educational institutions today. I mean, many professional colleges in I know for Tamil Nadu for sure, and I don't know if it's available. I mean, similar practices exist in other states where they say that girl students should not talk to boy students. Then there is a dress code, and you can't carry your mobile. You cannot, there's a lot of restrictions which are being imposed. So now, whether your right to free speech extends vis-a-vis the private players is something which is individual, one-on-one is again that is not what is part of the constitution because the constitution only contemplates state. But as far as big entities like Facebook or Google or any of these other big players are concerned, though it is in private hands, they are operating in the public realm where today almost the entire speech, the platform for speech has been the social media accounts. So it is now yet to be tested whether people can go to court. I think there is already a case pending in the Supreme Court. Mr. Sanjay Hegde, a senior counsel in the Supreme Court, has filed a case because his Twitter handle, I think, was or Facebook account was brought down without notice to him. And he has challenged it, saying that because they are operating in the public sphere, they should be made accountable to the public and they cannot arbitrarily decide and bring down accounts like this. And hence they should be subject to certain regulations and the same kind of equation that you would do vis-a-vis the state. So I think that is an area which is yet to be tested in courts. Yeah, can we go to the next one?
Yeah, the next one is from Subi Roy. It is the test of obscenity limited to the Indian artists or any work of art coming from artists of a different country before making it available to the Indian audience?
See, obviously, the artist in his own or her own country is of no concern for us because that's a different jurisdiction. Only when the artwork is brought into India for circulation in India does the law of India start to apply for them. So the question itself is answered partly by the condition of the question. So if it is going to be circulated in India, then obviously that person will have to take into account the laws in India. And the laws in India, which include the obscenity clause and both the protections for arbitrary action using obscenity as a reason to silence, vis-a-vis being able to challenge silence action through expanding on the obscenity issues.
Yeah.
Anyway, if it's a film, in any case, it has to be certified by the Central Board of Film Certificate, CBFC. I presume what you're talking about is an artwork in whatever form it is.
Yeah.
Okay.
The next
Okay,
Can you have-
move on to the next question. I wanted to ask, actually, this is my question also. As citizens, what can we do to unsilence free speech or respond to violations when it happens and exercise this right that we have learned about today? So as citizens, like today, if we have understood what the right means, as citizens, how do we go back to life and exercise this and respond to violations?
I think by being more and more expressive using the variety of forms which exist today, which did not exist, for example, when I was a youngster trying to understand politics and social change. There's so many new forms now, so we need to be able to do that. I think it also starts with the constitutional education. It starts by getting back to basics, understanding the reasons behind it. Like I said a little while back, talking about the constitutional vision, the dream of the constitution makers, talking about constitutional values, democratic ethos, democratic spirit. I think these are the starting points. We need to keep talking about it more and more for people to realize that these are not some romantic words. These are not words which lack any political substance. They're actually the substance of politics. That's the only way by which we can go forward. I shared with you the example in the last occasion of fishing community with whom I worked with, and told them about the fact that it's their government and the rights are recognized and not given to them by the government. The constitution has recognized that they already have inherent rights. That changed the tenor, the behavior, the speech, the discourse of these communities. That's my experience with working with many marginalized communities over the last 30, 35 years. That once they know their rights, their understanding of the political context changes. And people don't really require too much direction to be taught to challenge injustice when it happens. They do it. I strongly believe that people have an innate tendency to challenge injustice and to stand for fairness. By giving them this input, by helping them with this awareness and consciousness, we strengthen this process. We need to be the backups to support it in different ways.
I mean, if it is really, really offensive, I think one way is, I mean, experience has shown that once you start the criminal, you put the criminal machinery in the movement, then there is I think they quieten down by and large. So this has been the experience, I think, with regard to Chinmayi when she was trolled very badly. She gave a criminal complaint that stopped to a large extent. Then in Gujarat, I think hate crime recently, again, there are reports that people have initiated criminal action and that has somewhat quietened down. We are seeing globally where countries like Canada, in the Middle East, governments have now come down heavily on people who are actually abusing their freedom, and so the criminal law has been set in motion. So somewhere I think that element of the fact that the law will operate, that the law arm of the law will reach them is one angle, and the other is of course to cultivate a healthy climate of debate.
Just to give one practical example to say that this is again not some very theoretical type of solution. There is a lot of hate speech coming up in TV channels. So if you are listening to a channel which is broadcast from Delhi or Bombay or wherever, and you're sitting in Chennai, nothing stops you from filing a criminal complaint against that hate speech or a hate program in a criminal court in Chennai, in Karnataka, wherever else. So in terms of, for example, how the hate speech violates provisions of the Indian Penal Code or various other laws. So once you have more and more citizens actually moving around enforcing the law that we already have, that itself will start becoming a check against unbridled speech the way it is happening now. Can we have the next question?
The next question is from Fatima Bande. She says, I understand that the law defines the offense, the state defends it. But as we see in the political scenario of Jammu and Kashmir, many political leaders were jailed before the abrogation of Article 370. Is it not that the law is curved? Many common people were jailed for months together, even before the question of social unrest arose. How would the state defend the offense, which was not even committed, while the leaders were in prison and the free speech had no place?
Well, let me just clarify. It is the law defines the offense, the state defines the offender, not defends. Defines the offender. And that's just a small point of clarification. Yes, what's happening in Kashmir is a tragedy of multiple dimensions. One of which is the way many political leaders have been put inside jail a little before the actual promulgation of the ordinance of the law by which Article 370 was set aside. And some of those leaders are still in jail 9 months thereafter. There are the former judges of the Supreme Court and various high courts who have criticized the Supreme Court of India for being very tardy about handling many of these cases, and that raising issues about the fact that while a prominent TV anchor's case is heard within 12 hours of being filed. There are people who have filed 2-3 months before, whose cases are still not listed for hearing. This is the reality of the court functioning in India today, that these cases have still not reached any situation or solution in the courts itself. And time and again, further time is given to the state to come back with the various types of reports. Yes, it's an issue on which civil society will have to come together and keep on fighting and asserting the fact that it has to be a rule of law. And what's happening in Kashmir today is not a rule of law.
Thank you, sir. I'll ask the next question.
Yeah.
So his name is Sayantan. He's asking regarding freedom of speech and its connection to right to be educated. How do we see propaganda in this? So what if one bombards another with propaganda? Can propaganda be addressed or limited? How do you balance this freedom of expression and the right to information?
Well, it's interesting that Sayantan is using the word balance here, because all through the Constitution and the Supreme Court judgments, you always see the word balance coming up again and again, that in the context of free speech, it is a balance between individual liberty and social or collective interests. So if there is propaganda that is being unleashed, it's part of, we know that it happens. This is where teachers will have to get mobilized. Students, for example, in Kerala, there were examples of students coming together to challenge lesson plans in history which they felt was not right or which was not appropriate. So I think we'll have to mobilize different sections of people wherever we find that school curriculum is being more propagandist rather than in helping children to get a critical knowledge and critical learning and critical analytical capabilities.
I think the moment we understand that a particular thing is propaganda, then half the battle is won. So it is that critical understanding that is most important that we need to give. The moment children see it, or any public person sees it, and you see it for what it is, that it is nothing but propaganda, then I think already then your antenna is up, and then you are looking at it more closely and more critically.
See, there are many institutions which are responsible for textbook promotion. There are textbook boards. There are special committees set up on subjects, subject-wise. There is the state education department. Different states also have planning commissions and other things. I think multiple people will have to be approached and exposed to about what is happening. There's a SCERT and the NCERT. Various authorities are there overseeing education. We will have to approach all of them. Maybe many of them would share the same propagandist views that you are finding. But I'm sure that there would be people who would think differently. The challenge and the fight will have to be continuously push the boundaries of democratic action.
What is the time frame? Because I think we have it's already 8 minutes.
We decided to continue for another 8 to 10 minutes because we started late.
Okay.
We'll end with one last question though. This is from Balaji. It says, where is the line drawn between criminal defamation and civil defamation?
Between criminal defamation?
Criminal defamation and civil defamation.
Actually, there's no line drawn. A person can file both criminal defamation and civil defamation. These are two different jurisdictions under which action can be taken. Defenses are very different. Truth is not a defense in criminal defamation. Truth is a defense in civil defamation. So a person who's aggrieved by a certain expression saying that it is defamatory of her or him can exercise either or both of these options.
Thank you, sir. How are you both? How did you both think it went today? And we've had like 130 people, 132 people are online now, but we've had over 150 to 180 people watching and very actively asking questions and talking in the chat window. How are you both feeling? I just wanted to ask.
Well, it's always an intellectual joy to reach out to large numbers of people. Of course, it would have been much better if you could see people, but this is the next best option given the circumstances. It would be much happier if this dialogue and discussion can take place in continuous ways. And perhaps we'll have to discover how to do this, but we could think of that.
No, just to answer, I mean, I'm sorry, this is, there was one query, I think, which was sent well in advance, even before the session started, with regard to the foreign students who participated in the CAA protests. And there was one German student in Chennai from Madras IIT who was asked to leave India, and he left immediately. And then there was, I think, one student in one from Poland, I think, in Calcutta. Now, as far as the Chennai student, I mean, so there was a question about since freedom of speech is only applicable to citizens, what about foreigners? So as far as Chennai is concerned, of course, the student concerned did not challenge it, and he left the country. But in Calcutta, the student did go to the Calcutta High Court, and the Calcutta High Court had actually come up with a very, very progressive interpretation of the entire scenario. So he said, while yes, the person is a foreigner, the person who has come in is as a student, and when he comes in as a student, he has a right to life. So I think we have explained that the right to life and right to equality is something which is available to every person and is not restricted to citizens. So the Calcutta High Court said that since a foreign student has a right to life under Article 21, and the right to freedom of, I mean, he has right to life includes also right to liberty. And Article 14, which is the right to equality, which means you should not be subjected to arbitrary action. So he says when a student comes to India to study, it doesn't mean that he is living here without any sense of dignity, bereft of all rights as a human being. And so when he, as part of his intellectual pursuit, sees a public event and seeks to participate in it, and when there are no specific restrictions to his entry, he is validly in India, and there are no conditions in his visa as to what he should or should not do. And when there are no such restrictions, then he is perfectly within his rights to exercise his right to protest, and which they have read it into as part of Article 14, and in that as part of Article 21. And in that context, I mean, as far as the Calcutta incident is concerned, the student was not even given a notice as to why he should not be deported or why he should be deported, which means he was not given an opportunity to explain. So they also said that it is a violation of Article 14 because it's an arbitrary action. And in fact, they have gone a step further and says that the rights under 21 and 19, in fact, are linked. And so you can't really be exercising your right to life and the right to live with human dignity if your rights of free speech and free thought and right to freedom of association are all being curtailed. And so I think that is a very interesting judgment, and we should see how this is by a single judge. So I presume that the state will take it up on appeal. So, but it's a good beginning as far as rights are concerned.
Just to unbundle what Saila said, Article 14 and Article 21 reads any person, not a citizen. So Article 14 and Article 21 are available for not just a citizen, but for any person in India, whereas Article 19 is limited only to citizens. So it is a very interesting way by which the Calcutta High Court interpreted, without getting into Article 19, which is the right of freedom of speech and expression, which includes the right to dissent, reading 14 and 21 together and then bringing in Article 19 through that. Because Supreme Court has also held, and last time also I talked about it, Article 14, Article 19 and Article 21 are part of the basic structure of the Constitution. So it is a very interesting interpretation given to that issue in the context of Calcutta. But I think if such cases do happen, they should be challenged and we should take it up in the courts, saying that it is a student's right to participate in what is happening. And by being in a particular meeting does not necessarily mean that he's supporting X or Y, that it is part of a critical learning process. But these are issues that will have to be tested in the times to come.
Yeah, I think that's a good note to end on.
Yes, I just have to make just short announcements to all our viewers right now. We have started a Facebook page for you to stay updated We'll be announcing the following topics, what are the next week's lectures planned, reading material that we can share, videos. We're using the Facebook page to communicate. Please follow us. It's called Kudam. Also, the people who are asking for the presentation that was used by sir and ma'am, it's there in the description of the video. This video is going to be there on the same YouTube channel, and all the reading material that was given by mail is also in the description. For people who want to register and who haven't registered yet, there's a link to do that too, so that you can be emailed all of the reading material prior to the lecture. So I would also request all of you to subscribe to this YouTube channel and click the bell icon to receive notifications about our latest videos. And we apologize for the technical glitch that happened in the beginning, which caused this 10-minute delay and, caused us to shoot over time. I think that's it. It's really nice that we've had such a number today, and they've stayed throughout the video.
Thanks, Aishwarya. Thanks, others. Thank you, everybody. We'll meet on Saturday, same at 8 o'clock. We'll look at the other fundamental freedoms, Article 19, 1B to F. And we'll also hopefully start with Article 21, the right to life, on Saturday. So until Saturday then, bye. Please do keep in touch and share with us your views on how to improve, and also questions if you have any. Please do send it to us so that